Today, we will discuss the important distinction between recourse and non-recourse liabilities under Subchapter K of the Federal Internal Revenue Code, particularly as those differences relate to the taxation of entities taxed as partnerships. My name is Chad Cummings, and I am an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the law firm Cummings and Cummings Law. I also teach business law at the university level, and I hold 4 degrees, including 2 law degrees, and one of which is a master's degree in taxation specifically, as well as a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. First, let's perform a terminology check. Oftentimes, I will ask a business owner how their LLC is taxed, and they will stare at me as if I'm speaking Greek. Then, after a brief pause, they will confidently but misguidedly respond, I just told you it's taxed as an LLC. Well, I hate to break it to you, but an LLC or limited liability company is a form of legal entity recognized under state law. It is not a form of taxable entity recognized under federal law. And if your CPA or bookkeeper failed to explain that important distinction to you, then shame on them. The Federal Internal Revenue Service does not recognize an LLC as a taxable entity. Rather, depending upon the nature of the LLC, the number of members, and certain other aspects, which are well beyond the scope of today's presentation, but which I have covered in my earlier presentations, an LLC may variously be taxed as a sole proprietorship, a partnership, a subchapter C corporation, or a subchapter S corporation. And to make matters even more confusing, each of those legal forms is also a form of taxable entity recognized under the Federal Internal Revenue Code. Now, if none of this is making sense, please close out of this presentation and visit my firm website to schedule time for us to speak. Otherwise, what follows will only deepen and broaden your confusion. Now that we understand that partnership taxation may apply to true partnerships, which are relatively rare but not unheard of these days, as well as to multi-member limited liability companies, we can proceed confidently. In the realm of partnership taxation, managing liabilities effectively is crucial for both legal compliance and financial health. 2 primary types of liabilities that partners must consistently navigate are recourse liabilities and non-recourse liabilities. While these terms may seem straightforward, they encompass complexities that require a nuanced understanding, usually necessitating the guidance of a seasoned tax attorney and CPA. Recourse liabilities are those for which a partner bears a personal responsibility or personal guarantee. This means that if the partnership defaults, creditors can pursue the personal assets of the responsible partner. Now, conversely, non-recourse liabilities limit the creditor's claims to the assets of the partnership, thereby protecting individual partners from personal liability. Understanding the distinctions between these liabilities is paramount for the effective management of a partnership and risk mitigation generally. Recourse liabilities pose significant risks to partners as they extend beyond the partnership's assets. Partners with recourse liability are personally accountable for the debt, which can lead to severe and sometimes unexpected financial repercussions if the partnership defaults. This personal accountability underscores the importance of carefully structuring partnership agreements and understanding the full scope of potential recourse liabilities. One common misconception is that all partners are equally liable for recourse debts. Wrong. In reality, the allocation of liability can vary based on the partnership agreement as well as the specific circumstances of the debt and the underlying debt instrument. An experienced attorney and CPA can provide invaluable assistance in drafting competent and enforceable agreements that clearly delineate liability responsibilities, ensuring that partners are fully aware of their potential exposure. Non-recourse liabilities offer a layer of protection for partners by limiting the claims of creditors to the assets of the partnership. This type of liability is particularly beneficial in high-risk ventures as it shields personal assets from being targeted in the event of a default. However, the protection offered by non-recourse liabilities is not absolute, and partners must be vigilant in understanding the particular terms and conditions that govern these liabilities. While non recourse liabilities may seem less daunting, they often come with higher interest rates or more stringent terms, reflecting the increased risk to creditors, and they usually have less tax friendly attributes. Partners must weigh these factors carefully, balancing the punitive benefits of asset protection against the potential costs. Legal and financial professionals provide critical insights into structuring non recourse liabilities to align with the goals of the partnership and its constituent partners. Effective liability management in partnerships requires a strategic approach to liability allocation. Partners must consider factors such as the nature of the business, the financial standing of the constituent partners, the financial standing of the partnership, and the partnership's long term strategic objectives. A well crafted partnership agreement will address these considerations and others, providing a clear framework for allocating risk that minimizes exposure and fosters stability. One of the most common pitfalls in liability allocation is the failure to account for changes in the circumstances of the partnership. As the business evolves, so too may the nature and extent of its liabilities. Regular reviews of the partnership agreement, guided by an experienced attorney, can ensure that liability allocations remain appropriate and reflective of the current state of the partnership. Partnership agreements are the cornerstone of effective liability management, and every partnership and LLC should have one. These legally binding documents outline the rights and responsibilities of each constituent partner, including the allocation of recourse and non recourse liabilities. A comprehensive partnership agreement will address potential scenarios and provide mechanisms for resolving disputes, thereby reducing the likelihood of costly and protracted legal battles. Drafting a robust partnership agreement requires a deep understanding of both legal principles and the specific dynamics of that partnership. It should never be boilerplate. An attorney and a CPA can offer critical expertise in crafting these bespoke agreements that not only comply with legal standards, which are a minimum, but also reflect the unique needs and goals of the partnership and its constituents. This proactive approach can mitigate risks and enhance the resiliency of the partnership in the face of financial challenges. Misconceptions about recourse and non recourse liabilities can lead to significant financial and legal consequences for the constituent partners. One prevalent misunderstanding is the belief that non recourse liabilities offer absolute protection from personal liability. That is not always the case. In reality, certain conditions or guarantees may still expose partners to unlimited personal risk, further underscoring the importance of thorough due diligence and expert guidance. Another common misconception is that liability allocation is a static, check the box, one and done process. Also wrong. In truth, liability allocations usually need to be adjusted as the partnership grows and evolves. Regular consultations with a competent attorney and CPA working together can help partners identify potential liability issues at the outset and implement adjustments to safeguard the financial and operational health of the partnership and its constituents. Given the myriad complexities inherent in managing recourse and non recourse liabilities, professional guidance is indispensable. This is not the time to adopt the do it yourself approach. An attorney and a CPA can provide the expertise needed to navigate the intricate legal and financial landscapes, ensuring that partners make informed decisions that align with their unique goals. Professional advisors can also assist in identifying potential risks and opportunities, offering tailored solutions that enhance the partnership's resilience and competitiveness. By leveraging the insights and expertise of competent counsel, partners can confidently manage liabilities and focus on achieving their business objectives. In conclusion, managing recourse and non-recourse liabilities in entities taxed as partnerships under Subchapter K of the Federal Internal Revenue Code is a complex endeavor that demands careful consideration and expert guidance. By understanding the pitfalls and the nature of these liabilities and implementing strategic allocation and management practices, partners can mitigate risks and protect their personal and business assets. Ultimately, the key to successful liability management lies in proactive planning and collaboration with experienced professionals. With the right support, partners can navigate the challenges of liability management and position their partnership for long term and sustained success. Again, my name is Chad Cummings, and that I hope that you found this information helpful. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.